Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, we're going to be discussing the visa categorized as the P-1A visa. As I've discussed in another couple of videos on this channel, there are certain types of visas which can be extended for individuals they need work authorization on a non-immigrant basis for like a sort of a temporary basis in the United States, but they don't meet the general requirements of like industrial workers or, agricultural workers, etc. They oftentimes fall into categories which can only be described as like athletics or entertainment. And the P-1A is no exception to that. In fact, the P-1A is specifically designed for such things. I often find it's often best to go to the horse's mouth, so USCIS, under the auspices of the Department of Homeland Security, has this to say about the P-1A visa. And I quote, "The P-1 classification applies to you if you are coming to the U.S. temporarily to perform at a specific athletic competition as an athlete, individually or as part of a group or team at an internationally recognized level of performance." That's a term of art there, internationally recognized level of performance. You must be coming to the individual athlete's eligibility criteria. You must be coming to the United States to participate in an individual event, competition, performance in which you are internationally recognized with a high level of achievement, evidenced by a degree of skill and recognition substantially above that ordinarily encountered, so that the achievement is renowned, leading or well known in more than one country. And then to come to the United States, your U.S. employer must file a Form I-129 petition for non-immigrant worker, accompanied by the appropriate fee and supporting documentation. The supporting documentation in such matters is going to vary. It's going to vary case by case. And look, obviously the Olympics would be covered by something like this if we had an Olympics in the United States where individual athletes needed to come to the United States to compete in that event. And the internationally recognized criteria would relatively easily be covered by that event. That being said, more amateur athletic events, I guess I should say less well-known, less notoriety athletic type events, and less sports with less notoriety may not necessarily fit under the international recognition operative phraseology, if you will. So there's the supporting documentation and the circumstances specific to the individual applying for a P-1A are going to be critical with respect to ultimate approval, because the individual in question, it may be a sport, and it can actually operate to someone's favor if a sport isn't particularly in the spotlight. So for example, and there are various sports that simply don't have the level of recognition in the United States that, say, other types of sports do. But for example, there may be major bowling tournaments, for example, in the United States, and although bowling isn't maybe quite on the level of, say, professional baseball in the U.S. or professional football or Olympic level sporting events, one who's one of the best in the world, one of the top 3 people in the world with respect to professional level bowling, they may be eligible for a P-1A visa. Whereas somebody who's sort of more middle of the pack in something in a sport that may be more highly recognized, someone who may not have quite the level of ability in a sport that may be more recognized internationally, may not meet the requirements for a P-1A. So again, this is going to be very circumstantially based, the P-1A and issuance and approval of petitions related to a P-1A. But that being said, P-1As can be a way in which various athletes can get into the United States in lawful status.